Hi, my name is Haris Anberson and my metric card number is DIL192016, and today I'm going to present about poster description or definition. So let's get started. The poster is not just defining the title itself, but we poured our heart out on each and every word we wrote on it. So we also express the patriotic side of us and build hope within the faith that we all carry till now. We will go through this one by one as stated in our poster, as you all know that our main topic is freedom of religion under Article 11 Nation's Federal Constitution, which loudly and strictly allows people to choose their own faith and beliefs except for Muslim. So this is stated in Article 3 and supported by Article 160 of the Federal Constitution. So throughout the process of making this poster, we believe that article deserves all the defense and protection. When there is religion, there will always include faith, pride, and dignity as well. According to our understanding, religion brings out beliefs, and all humans beings have the full right to choose based on their faith. But we must also understand one thing, that everything in this world, including in a person, we all stand by rule. Without rules, there will be chaos. The same goes to this article where Muslims are prohibited to convert any other religion. And this is strictly bind to the constitutional law. This is because Malaysia is a Muslim country and the law itself is accordance to Islam as a citizen. We have no choice but to obey it. As long as it's not against or violates that is binding the law, we believers deserve all the respect, and due to that we will unite. As we all know, there is no wrong in any religion, but it's all about standing on what lies in our heart to choose what is the best. When we are free to choose our own religion, we will automatically learn to respect one another, and this will make us to be unite as well. So finally, from this without, we realize it will grow our humanity that has promised us morality, love, and respect within ourselves. That's all from me. Thank you.
Assalamualaikum everyone. Before I start, let me introduce myself. My name is Aida Kasrina binti Azahar. My metric number is DIL192009. Today, I would like to take this opportunity to present about Article 11, Freedom of Religion. So, I will start off by the introduction of the article first. As you all know, Malaysia is a multi-racial country with citizens who practice various religious beliefs. The freedom of religions forms part of the fundamental right enriched under Federal Constitution to protect the right to freedom of religion or belief, including religious manifestation by way of professing, practicing, and propagating one's religious belief. Islam is spelled out as the religion of federation, for it is the religion of the indigenous inhabitants, the majority population, who is the Malay. The cases of religious freedom, however, have been independently deliberated under a number of provisions. Article 3 Clause 1 states about the freedom of professing religion in view of that Islam is recognized as the official religion of Malaysia, and other religion can be peacefully practiced in any territory of the Federation. Albeit there is freedom, it is respectfully argued such statement is limited and subjected. This, however, does not affect the right of non-Muslims to practice and profess their own religion, as the wording of Article 3 Clause 4 states that nothing in Article 3 derogates from any other provision of the Federal Constitution. Islam is the religion of peace, does not promote any manner of compulsion. Meanwhile, Article 11 Clause 1 adds on the freedom to practice religion that every person has the right to profess and practice his own religion. However, such freedom does not include the freedom of propagating one's religion, as it made subject to Article Clause 4, in which the state and federal laws have control and restriction over the propagation of one's religion to the Malays. So, any person who propagates religious doctrines or belief other than the religious doctrines or belief of Islam among persons professing the Islamic faith shall be guilty of an offence. Next, the Constitution in Article 160 defines The Malay as a Muslim who habitually speaks Malay adheres to the Malay custom born in Malaya or Singapore before or on Independence Day and reside in Malaya or Singapore. It is explicit from the definition that the Constitution ties the Malays with Islam. This article therefore classifies freedom of religion as stipulated in the Constitution into three categories, which are freedom to profess, to practice, and to propagate religion. Anyhow, the Constitution has reflected some basic principle taught in Islam pertaining to the freedom to profess, freedom to practice. Besides that, it is important to emphasize that justice is universal value adhered to by all the religions, whether or not Malaysia is an Islamic country, and hence whether or not the Constitution is Islamic. Also, it is essential that Malaysia to uphold justice for people of religions in Malaysia. That's all from me. Thank you. Now I will pass to next presenter.
Assalamualaikum warahmatullahi wabarakatuh. So my name is Zaratu Shamdam Tisabah. My matric card number is DIL 192006. So I will continue with the application of Article 11 of Federal Constitution in Malaysia. The application of religious freedom in the Malaysian Constitution stipulated for three aspects of religious freedom. They are the right to profess, to practice, and to propagate religion. Firstly, the right to profess a religion. This is based on Article 3, Subsection 1 and Article 11, Subsection 1. However, the Constitution is rather specific about the Muslim freedom of religion. The Constitution refers such issues to the jurisdiction of the Sharia court, for they are confined under the purview of the Islamic laws. On the other hand, the Constitution does not case any specific prohibition for the non-Muslim from professing any religion or from converting to any other religions. Such freedom is also granted even though they were non-Muslims. In Article 160 of the Malaysian Constitution define the Malay as a person who professes the religion of Islam, habitually speak the Malay language and conform to the Malay customs. This article should be read with Article 11 Subsection 4, which prohibit propagation of religion other than Islam to the Muslims. This article is implicit prohibition for the Muslim to convert. Secondly, the right to profess a religion. In Article 11 Subsection 3 of the Federal Constitution states that every religious follower is granted to the right to practice the religion, manage the religious foundation, and amass wealth. The article also provides other rights that allow the founding of religious association, such as attending mass gathering, building of shrine, founding of educational institutions, forming a welfare bodies, use of holy scriptures, amassing of wealth, and propagating religion. It includes the right to form religious association, where the government allow any ethnic community to form religious association either as a registered association or a registered company. Every ethnic community is also granted the opportunity to build their places of worship, since the building of religious shrines often leads to sensitive issues and controversies. The government enacted a constitution that adheres to the Islamic laws, where every ethnic community is provided the opportunity to build their holy structure. Lastly, the right to propagate a religion. The Constitution limits the propagation of one's religion to the Malays. A Malay is defined by the Constitution a Muslim, and therefore propagation of other religions to a Malay runs against the Constitution. This as stipulated in Article 11 Subsection 4, State Law and Federal Territories of Kuala Lumpur, Labuan and Putrajaya. Federal law can control and restrict the spread other faiths or religious belief toward Muslim. As a result, a few rules were enacted under the State Act to control the Muslim religious freedom, like Kelantan, Terengganu, Pahang, Kedah, Melaka, Johor and Perak had adopted the act to control and restriction of the spread of other religions to the Muslim. Some states, however, have not taken a similar action, including the Federal Territories of Labuan, Kuala Lumpur and Putrajaya, Pulau Pinang, Sabah and Sarawak. So that's all from me. So I will pass to the next presenter. Thank you.
Hi, Assalamualaikum warahmatullahi wabarakatuh. My name is Nurah Ahwat Syafiqah binti Sulaiman. My matric card number is DIL 19-2005. So, I would like to proceed about the case of Lina Joy against Majlis Agama Islam Wilayah Persekutuan and others in Federal Court. So in this case, the plaintiff was born as a Muslim. She was brought up as a Muslim, or her upbringing was conducted on the basis that she was a Muslim. She lived as a Muslim with her family and commonly reputed to be a Muslim. The plaintiff's parents are both Malaysian. She had applied to the National Registration Department, which is NRD, to change her name from Azlina Jailani to Lina Jailani, and in supported state inter alia that she intends to marry a guy that Christian. The application was, however, rejected. By an originating summons, the plaintiff had applied to the High Court for various declaratory orders, which is namely her rights to religious freedom, which is in Article 11 Clause 1 of the Federal Constitution. That's Section 2 of the Administration of Islamic Law Federal Territories, which is the Act in 1993, and other related state enactments were null and void as they were inconsistent with Article 11 Clause 1 of the Federal Court. That Sharia Criminal Offence Act 1997 and other related state enactments were not applicable to the plaintiff, who had professed the religion of Christianity, that any laws, whether state of the legislation which forbid and impose restriction of the conversion out of Islam, were null and void, being inconsistent with Article 11 Clause 1 of the Federal Court. The help of the judgment given in Article 11 Clause 1 should not be read in isolation. It must be construed harmoniously with the other relevant provision on Islam, which is namely Article 3 Clause 1, Article 12 Clause 2, Article 74 Clause 2, and 121 Clause 1A, and 160, where a Malaysian is defined as a person who professes the religion of Islam, which is namely Article 3 Clause 1, Article 12 Clause 2, Article 74 Clause 2, and 121 Clause 1A, and 160, where a Malaysian is defined as a person who professes the religion of Islam. Next, the plaintiff cannot hide behind the provision of Article 11 Clause 1 of the Federal Court without first settling the issue of renunciation of her religion, which is Islam, with the religious authority which has the right to manage its own religious affairs under Article 11 Clause 3 subsection A of the Federal Court. Since the plaintiff was still a Muslim, in Article 121 Clause 1A provides that the finality of her decision to convert out of Islam was within the competency of the Sharia Court and not the Civil Court.
Hi, Assalamualaikum. My name is Najwa Nurul Dilaila binti Samsul and my matric card number is DIL 192003. Okay, so next we move to the second case law, which is the case of titular Roman Catholic Archbishop of Kuala Lumpur against Menteri Dalam Negeri and others. Okay, so for the fact of the case, this was an application for leave to appeal against the decision of the Court of Appeal in ruling that the first respondent in prohibiting the applicant from using the word Allah in the Malay version of its weekly publication, which is the Herald, was acting intra vires the law and the Federal Constitution. In consequence to the prohibition, the applicant applied inter alia for an order of certiorari to quash the first respondent's decision. In quashing the first respondent's decision, the High Court held that the decision was illegal and unconstitutional, and that the applicant had a constitutional right to use the word Allah. However, the Court of Appeal set aside the orders and the decisions of the High Court. the first respondent's decision to impose a condition on the herald came squarely within the function and statutory powers of the minister and was intra vires the Constitution, the Printing Presses and Publications Act 1984 or the rules. In the present appeal, the applicant argued that there was uncertainty as to the source of the power under which the first respondent imposed the conditions and prohibition in question. The Court of Appeal, in determining the reasonableness of the first respondent's decision, had applied the wrong subjective test instead of the objective test, and the questions and issues posed to the Federal Court had passed the threshold of Section 96 subsection A or subsection B of the Courts of Judicature Act 1964. Next, judgment of the case. Based on Article 3, subsection 1 of Federal Constitution, it states that Islam is the religion of the Federation, but other religions may be practiced in peace and harmony in any part of the Federation. It held that the words peace and harmony were meant to protect the sanctity of Islam as a religion of the country and insulate it from any possible threats, which in Malaysia is the propagation of other religions to the Muslim. In the court's view, the use of the word Allah had the potential to disrupt the even tempo of the life of the Malaysian community, having an adverse effect on the sanctity envisaged by Article 3, subsection 1 and the right of other religions to be practiced in peace and harmony. The minister was clearly concerned with national security and public order when making his decision. The court was required to execute a balancing exercise between the requirement of national security and public order and that of the interest and freedom of the respondent, but was not to for strong evidential proof of national security. There was no violation of the respondent's right to profess, practice and propagate his religion under Article 11. The history of the language of the Bible showed that the word Allah was not used as the name of God and was not an integral or essential part of the faith and practice of Christianity, and therefore the prohibition on its use by the publication did not inhibit the respondent from practicing his religion under Article 11. Okay, the last one, ground of judgment. Okay, the last one, ground of judgment. The following passage of his judgment shows that the learned judge had also applied the proportionality principle, where he stated, "It is my judgment that based on the facts and circumstances of the case, the usage of the word Allah, particularly in the Malay version of the Herald, is without doubt do have the potential to disrupt the even tempo of the life of the Malaysian community. Such publication will surely have an adverse effect upon the sanctity as envisaged under Article 3, subsection 1, and the right for other religions to be practiced in peace and harmony in any part of the Federation. Any such disruption of the even tempo is contrary to the hope and desire of peaceful and harmonized coexistence of other religions other than Islam in this country." Based on the reasons given by the minister in his affidavit in reply, it is clear that he was concerned with national security and public order.
Hi, my name is Anisha Zahira. My metric number is DIL 192010. So today I'm gonna present about the part of conclusion. In our opinion, with respect to freedom of religion, the words in the Malaysian Constitution declare the right to profess and practice one's religion as absolute. This is clear as there are no express provision to limit one's profession and practice of faith in any certain circumstances. Life is, however, more than just words on piece of paper or laws, and shine in the hall of Parliament and apply in the stately courtrooms. Law are subject to human interpretation and very much influenced and moved by the politics of the day. In Malaysia, the ideologies and politics of the day, the rhetoric of race and religion, the self-interest mobilization of religion by the political community, and the ignorance of many have resulted in religious freedom being compromised and slowly eroded. How Malaysians begin to defend and in some instances reclaim this right is the critical challenge and need ahead. But Malaysians do not live as an island unto themselves. We now live in an advanced interconnected world. Every contact and connection matters. Hence, every person or community that reads and understands the intricacies of Malaysian life with respect to freedom of religion presents itself with opportunities to help and to mobilize change. Thank you. That is all from our group.
Hi everyone, my name is Yoganathan. My metric card number is DIL191018. Okay. More than 260 million children are out of school worldwide. Discrimination of marginalized group by teachers and other students, long distance to school, formal and informal school fees, and this absence of exclusive education are among the main causes. Millions stop going to school to work. School to work mean long hours, often under hazardous conditions. Other experience violence or abuse from teacher or fellow students, or find their schools target of armed attack. Families do not send girls to school, force them out of school to marry, or deny an education when they become pregnant. Many are kept from getting a secondary education because they cannot afford school fees. Even when in school, millions of children receive a poor quality education that leaves them lacking essential skill and knowledge.
This poster of Article 12 describes that all human beings have right to educate themselves, no matter what their ethnicity, age, gender, religion, and belief. According to Nelson Mandela, quote that education is the most powerful weapon that you can use to change the world. For example, Nelson Mandela used his intelligence and his entire life to fight for equality and ultimately help topple South Africa racist system of apartheid. So due to that, all human beings have right to educate themselves to change the world for a better life and the future.
Assalamualaikum everyone, my name is Muhammad Irfan bin Rahmat Faizal, DIL193015, and today I will be presenting about the articles published online related with the Article 12 of the Federal Constitution, which is the right to education. Firstly, a related news article called All Children Have a Right to Education by Proham, published in 11 January 2018. In this article news, the author is concerned about the Immigration Department and the Education Department are depriving stateless children. So, Malaysia is a signatory to the Convention on the Rights of the Child, making it a duty on the part of the government to uphold its commitment to the protection and welfare to all children. Children's rights under the convention include the right to associate with both parents, human identity, physical protection, food, universal state-paid education, healthcare, and the child service rights. Hence, all states being parties to the convention must ensure that the guarantee these rights to each and every child irrespective of whether they are citizens, stateless, or refugees. Every child is entitled to the right and freedom in this convention without distinction or discrimination of any kind, such as race, color, sex, language, religion, national and social origin, birth, or any status. This is related with the statement provided by the Article 12 of the Federal Constitution, which has clearly stated the right for education, that everyone has the right in receiving education no matter how different they are. Secondly, is a related news article called "The Rohingya Refugees Have No Rights, but Children Can Access Education" by Minister Muhammad Razif Muhammad Chibin, published in 4 August 2020, stated that even though the Rohingya refugees have no rights in Malaysia, the government still insists in giving the children access to alternative education. According to Minister Muhammad Razif Muhammad Chibin, said that the children of refugees are accorded the same access to the curriculum of their country of origin or of a third country via Alternative Guidance Center PBA as other non-citizen children. This action supports Article 12 of the Federal Constitution in providing people's rights to education even they are not born in the same state. Thirdly, is a news article called "Malaysia, the Right of Education for Children with Learning Disabilities" by the Human Rights Commission of Malaysia, SUHAKAM, published in 2015, stated that they are aiming to increase the number of children with learning disabilities in receiving inclusive and quality primary education. This is to identify the challenges that the children are facing with learning disabilities, including logistic difficulties in accessing learning facilities, inconsistent implementation of screening and assessment processes, the lack of adequate funding for programs, and the lack of adequate support in learning institutions. Therefore, it would be easier to provide the children the help they need, which the government will be able to efficiently improve access to education for the community. Even with disabilities, the Article 12 of the Federal Constitution does not discriminate their right to receive education. That's all from me. I will pass it on to the next presenter.
Assalamualaikum, Madam. My name is Ilana Tashamanti Umar Nazrin, DL 193034. I will be talking about the related cases in Article 12. So, in the case of Teo Ong Huat against Kadi Pasir Mas and another, 1992 M1301, the fact was, in this case, the plaintiff learned that his daughter, aged 17 years, had been converted to Islam. This was without his knowledge and consent, according to the affidavit of the plaintiff attached to his application dated February 3, 1986. His daughter, Suzy Teo, which is the infant, was born on April 5, 1968 and was working as a clerk at MERS. Video real at Jalan Tok Lam, Kuala Terengganu until December 18, 1985, when she was discovered missing by her boyfriend, Tan Boon Hui, after a futile search for her in Kuala Terengganu, Kuala Lumpur and Penang. The plaintiff's son-in-law, Chi Ki Hong, alias Chi Chi Hong, had lodged a police report on the matter on December 21, 1985, and had subsequently telephoned the first defendant office to inquire whether the infant had recently been converted as a Muslim, and was told that she had in fact been converted on December 22, 1985. He applied to the High Court for the following declaration and orders, which is a declaration that he, as the lawful father and the guardian of the infant, has the right to decide her religion, education, and upbringing. A declaration that the infant shall continue to be brought up in the Buddhist faith in accordance with his wishes. C. A declaration that the infant's conversion into the Muslim faith made sometime between December 18 and 22, 1985 by its first defendant without his consent is null and void, and ordered that the registration of the conversion of the infant to the Muslim faith in the records of the second defendant be expunged. Cause and such further or other order as the Honourable Court deemed fit and proper. It was held that the girl in this case had the right to choose her own religion, if she does it on her own free will in view of Article 11 and 12 of the Federal Constitution. Second, the application in the first prayer as regard the right to the plaintiffs to decide the infant's religion should therefore be dismissed. The Guardianship of Infants Act 1961 applies in Kelantan and applies to both the plaintiff and the infant in so far as the provision were not contrary to the Muslim religion. The father is under the Guardianship of Infant Act 1961, the guardian of the infant, and he has the custody of the infant and is responsible for her support, health and education. The court was deprived of the opportunity of interviewing the infant in this case, as her whereabouts was unknown and therefore could not make any order under Section 10 of the Act with Section 5 thereof. Number 5, the application of the plaintiff in regard to the right to decide on the education and upbringing of the infant until she attains majority is allowed, subject to the condition that it does not conflict with the principles of the infant's choice of religion guaranteed to her under the Federal Constitution. The other subsequent prayers are dismissed with cause.
For the comment regarding Article 12, in my opinion, even though it's stated that everyone has the right in receiving education, however, there are others out there who are still not giving out education to people in excuse not fulfilling the requirements or qualification. Therefore, I urge the government and the relevant department to immediately put a stop to this issue so that every people living in this country to be given his or her basic human rights, namely the right to education, no matter how different they are to us. That is all for Article 12. Thank you for listening.